Welcome everybody to this tax law research program webinar, TLRP webinar. My name is Richard Cullen and I'm the convener of the TLRP at Hong Kong University in the Faculty of Law. We're really pleased to have Professor Wei Choi speaking to us again. He spoke last on a TLRP webinar back in April of last year when he talked about the administrative foundations of the Chinese fiscal state. And I'll introduce today's topic in a moment. So Professor Wei Choi also. But let me just deal with a couple of housekeeping matters first. Firstly, Professor Wei has kindly made his, Professor Choi, I should say, has kindly made his PowerPoint slides available. So after the webinar, we'll be uploading those onto the AIIFL TLRP website. You'll be able to access them. Next, this webinar is being recorded. So if you wish to, you will be able to access the recording at a later time. And then finally, today, Professor Choi will speak for about 45 minutes or so. And we welcome, of course, any questions you may have. And the way to do that is to enter your question on the Q&A service provided by Zoom. And I'll be able to read them, but more importantly, Professor Choi will be able to read them, and he will respond to those after he's finished the presentation. Now, let me just say a few things about Professor Choi. Many of you will be back again and will be familiar with him, but briefly, he teaches at the Peter A. Allard School of Law at the University of British Columbia, a very well-known law school in Canada. And his scholarship spans a wide range of topics in tax law and policy, including international tax, rationales for global tax cooperation, strategic incentives for adopting the global minimum tax. We'll be talking about them today. The destination-based cash flow tax, VAT matters, capital gains tax, and so on. And he's the editor of a number of significant books, which are widely referenced, and a large number of articles, and he's been a visiting professor at places like New York University Law School, Michigan, Columbia, and Melbourne Law Schools, and several other institutions. Before he became an academic, he practiced US and Chinese tax law for over 10 years in New York and Beijing. And during the period 2009-2010, he was senior tax counsel at the China Investment Corporation, and he's also served as a consultant to China's National People's Congress, Ministry of Finance, and State Administration of Taxation, as well as United Nations. It's a great CV, and we know from past experience Professor Choi will be providing an informative webinar today. I'm looking forward to it, hoping I can keep up with it because it's quite complicated, but it's really important. So Wei Choi, over to you, and thank you again for joining us. We're really grateful to have you.
Okay, thank you so much. So let me get started. So the talk's title is Strategic Incentives for Adopting the Global Minimum Tax. It's a topic in international taxation. And many of you know that the government of Hong Kong actually launched a consultation a month ago on implementing the tax that I'll be talking about, the OECD's Global Minimum Tax Proposal, also known as Pillar 2. So I'm very happy to have this opportunity to present a paper, a scholarly paper on this topic to Hong Kong stakeholders while this is happening. What I'll do is to sketch out a theory about whether countries have self-interested reasons to adopt this proposal, Pillar 2, that's now considered around the world. The theory has general application to all countries considering the same proposal. but I think it has interesting and perhaps surprising implications for Hong Kong. And so I'm very interested in your feedback. Let me say that the paper is posted to SSRN. If you're interested in what I'm saying, but find some of the arguments confusing, the paper may help clarify. I'm also happy to be contacted. I'll also begin by saying that the paper and the talk, they are on a topic that many of you will have seen other presentations of, but this is going to be different from other things you've read and heard about Pillar 2. And the reason is that for several years, most of what we heard about Pillar 2 is coming from tax advisors. In fact, back in 2022, the magazine The Economist stated that one of the few predictions that can be made about Pillar 2 is that a bonanza awaits tax lawyers and accountants. In my talk, I'm going to offer a simple sketch of the components of the global minimum tax. So I'm going to step back from all of the jargon and detailed rules of Pillar 2 and ask the question, what is driving Pillar 2 adoption besides the bonanza promised to tax professionals? So I will tell you my main conclusions. The first main conclusion is the following. Even when a significant number of countries initially adopt Pillar 2 may still unravel as long as countries act out of national self-interest in the long term. So I expect this to be a surprising conclusion for many of you. So let me explain why this conclusion is important first, and then I will show you, summarize the arguments. So both governments and tax advisors have engaged in predicting whether Pillar 2 will be widely adopted. In the case of tax advisors, the prediction affect whether they will have a new line of business or not, and how large that line of business will be. Many people seemed so much to want Pillar 2 to happen that they assert, misleadingly, I believe, that back in 2021, over 100 countries agreed to implement Pillar 2. Others have been more skeptical because what happened in 2021 was the release of several press releases by the OECD, and whether this would result in global action seemed unclear. However, at the end of 2022, the European Union formally adopted a directive on Pillar 2 implementation. And by the end of 2023, over 20 countries have formally enacted Pillar 2 legislation. A very popular claim that some of you will have heard is that a critical mass of countries adopting Pillar 2 is sufficient to get Pillar 2 to be adopted more widely. So the argument of this paper is aimed to show that this view is wrong. The claim that the adoption of Pillar 2 by a critical mass of countries, whatever that means, will ensure Pillar 2's global implementation is mistaken. So this is, of course, important because when governments like Hong Kong are deliberating about whether to adopt Pillar 2, assumptions about what other countries will do will be unavoidable and also critical. So what are the arguments for my conclusions? Here's a quick summary. Countries from which large multinationals originate will bear heavy financial losses from Pillar 2. Therefore, they should have little incentives to embrace it. In particular, adopting what's called the income inclusion rule, something I will explain, is irrational. This conclusion applies to countries like China, the United States, two countries that have not acted on Pillar 2. It applies to Canada and Germany, countries that have initially announced legislation on Pillar 2, but that things may still change. Low tax countries may temporarily benefit from raising taxes on the multinational subsidiaries they host by enacting what's called the Qualified Domestic Minimum Top-Up Tax, QDMT. But this may not last. And so the paper argues that if we observe QDMT adoption now, it is still a poor indicator of the long-term viability of Pillar 2. And finally, the most important part of this first set of arguments is that most countries do not have reasons to fear Pillar 2's purported enforcement mechanism, the undertaxed profit rule, also known as the UTPR. And so many claims that have been made about the UTPR's enforcement effect is illusory. So Because of time limitations, I'm going to focus on the arguments on the previous slide, but a second main conclusion of the paper is that there are fundamentally unresolved issues regarding the legality of critical aspects of Pillar 2. These legal issues may significantly affect implementation. In particular, the paper argues that commentators on Pillar 2, including both proponents and critics, have talked about the undertax profit rule in confused ways, sliding back and forth between two interpretations. One is an extraterritorial interpretation, the other is a non-extraterritorial interpretation. In my paper, I argue that these two interpretations have equivalent effects under current Pillar 2 design. They both fail to enforce Pillar 2, but the extraterritorial interpretation implies a new taxing right that poses fundamental challenges to international law. And in their rush to either promote or attack the undertax profit rule, commentators have confused this issue. An important objective of the paper is to clarify this confusion. The paper suggests that the design of the qualified domestic minimum tax also contains seeds of controversy. Okay, here's the roadmap of the talk. I'm going to provide a schematic example illustrating Pillar 2's components. I'm going to explain why the income inclusion rule is irrational to adopt. Then I will explain why the enforcement power of the UTPR is illusory, and why the UTPR is dangerous even when it fails to enforce Pillar 2. I'm going to consider just one set of objections and replies. In particular, some of you ask, do countries act out of self-interest in the sense of maximizing national income, which is a key premise of the paper's arguments. I'm going to try to address that. And finally, I'll touch on the implications for Hong Kong briefly. Okay, I hope that we're ready to go. Let's come to the schematic example. To understand Pillar 2, we can start by considering 4 types of countries. And so here, let's consider a multinational group M within the scope of Pillar 2. M has an ultimate parent entity, P, in country U. I think of U as representing all countries from which a significant number of multinational enterprises originate. Examples of countries like U, UPE jurisdictions, include the US, China, Germany, Canada, and so on. Okay. These countries host the headquarters of multinationals. They also offer tax incentives to both domestics and foreign multinationals, such that companies operating within them may have low effective corporate income tax rates, low meaning below 15%, which is the minimum required by Pillar 2. So this is country type 1. M also operates in countries X and Y, which represent a second type of countries where the corporate income tax rate are relatively high. One can think of France, Germany, and so on. In contrast, there's countries of a third type, represented by Z here, which host multinational subsidiaries, but offer favorable treatment to them. Many countries, of course, will fall into this type. People might think of Hong Kong as belonging there, Ireland, Switzerland, and so on. And fourth and finally, M has a holding company, which is referred to in Pillar 2 as the intermediate parent entity, IPE, in country H. And in this type of country, the effective tax rate on corporate income is close to 0. So examples here include Luxembourg, Hong Kong, or Bermuda. As you can see, any single country, such as Hong Kong, may belong to any single jurisdiction, such as Hong Kong, may belong to more than one jurisdiction type. Okay, here is the income inclusion rule. The aim of Pillar 2 is to ensure that a covered multinational group bears a minimum 15% of effective tax rate in each country it operates. Here we have a low tax subsidiary in country E, and one solution in country Z. One way of dealing with this is for the application of an income inclusion rule to come into place in U. U, as the country where the ultimate parent entity of the group M is located, may impose a top-up tax on P with respect to the low tax profit of M's country Z subsidiary. The amount of this top-up tax is a function of the difference between the 15% minimum required by Pillar 2 and the actual tax rate displayed by the Z subsidiary. The idea is that the top-up tax imposed on country U plus any country Z tax already imposed on the Z subsidiary's profits ensure the minimum taxation of this profit. Suppose that U does not adopt the IIR. Pillar 2 says country H can adopt the IIR. My paper argues that H is unlikely to do so. For now, let's just assume that no country, neither U nor H, imposes the income inclusion rule. This means that the subsidiary in Z still has low tax profit. Now, Pillar 2 provides that country X or country Y, or the two collectively, can step in and impose the undertax profit rule, UTPR, with respect to the profit of the Z subsidiary. They will collect the top-up tax from the X or Y subsidiaries of M, corresponding to the tax that was not collected in Z. Note, moreover, that M has low tax subsidiaries in country U. The IIR wasn't going to do anything about this. According to Pillar 2, X and Y can also collect top-up taxes on their respective subsidiaries with respect to the low tax profit of these country U subsidiaries. Here's the final component of Pillar 2. So for those of you who haven't been exposed to this, this is the final step. There's something called the QDMT, the Qualified Domestic Minimum Tax, which may be adopted either by Z or by U. Remember, these are the two countries that have low taxation. And so Z may adopt the QDMT to raise the effective tax rate of M subsidiary here to 15%. If it does so, Pillar 2 says country U can no longer apply the IIR as a top-up tax because these subsidiaries' profit is no longer low taxed. For the same reason, X and Y can no longer apply the UTPR with respect to the Z subsidiary. Okay. Z could have precluded the application of the IIR and the UTPR by raising its tax rates in general or counting back tax preferences, but the QDMT allows Z to avoid this general policy change and offers a more targeted response to other countries' threats. Okay, so that's a whirlwind through Pillar 2. For those of you who followed the OECD proposal, this will be very simple. You will see I omitted many details. Now, the gist of my argument is, in a way, that the emperor has no clothes. And so I'm not going to dwell on the splendid design of the emperor's robe. This is enough for us to look at the main arguments. The first main argument is that the income inclusion rule is irrational to adopt. Okay, here is the set of arguments. UPE countries, multinational headquarter countries like Germany, Canada, etc., currently tax their multinationals' foreign profits lightly. This encourages profit shifting by these multinationals to low tax jurisdictions. The income inclusion rule, if it were adopted by these countries, would increase the tax on such foreign profits that mechanically raises revenue, and it also reduces profit shifting incentives. What's notable is that if such a tax is imposed, the revenue comprises intra-nation wealth transfers. The idea is that the profit of M's foreign subsidiaries actually represents a part of country U's national income, just like U's tax revenue. So what such a tax does is to move part of national wealth in U to another part of national wealth in U. In contrast, the QDMT that's imposed by a host country would result in an inter-nation wealth transfer from the wealth of shareholders in U to country Z. Many jurisdictions, such as Switzerland and Hong Kong, would impose the QDMT only if other countries, such as Canada, Germany, the US, or China, impose the income inclusion rule, but effectively give a foreign tax credit for the QDMT. effectively, the rule is to say, you collect the QDMT, we will not collect any tax on the IIR. Okay. But what that means is that the UPE countries would enact a top-up tax only to enable large transfers of wealth to other countries. And this is a large loss in national income, which national income maximizing government should not do. Okay, so let's see how large is this wealth transfer. It is very large, okay? So a study by two German economists, Fuess and Neumeyer, calculated the revenue gains governments can expect from implementing the IIR. They estimate that if Germany adopted the IIR but nothing else changed, it could raise up to 6.7 billion euros of revenue a year from German multinationals. Since German multinationals will engage in less profit shifting after German IIR adoption, an additional 1.4 billion euros of revenue may be raised from our German multinationals. So altogether, 8.1 billion. However, this revenue of 8.1 billion is a matter of wealth transfers within Germany. It's moving from one account in Germany's national income to another account. However, if in reaction to Germany's income-linked conclusion rule, jurisdictions like Hong Kong adopt the QDMT and apply it to German multinationals' foreign subsidiaries, German multinationals will have to pay so much more tax abroad that Germany will collect no revenue from the IIR. It would actually collect only about 1.9 billion of revenue from reduced profit shifting. In other words, the execution of an intra-nation transfer of 1.9 billion euros was cost Germany a loss of about 5 to 6 billions of German wealth to other countries. There's nothing special about Germany in this analysis. The same conclusion applies to the US, China, Canada, etc. Fuess and Neumeyer calculate that for all countries other than the US, the IR annually would result in aggregate additional revenue of 21 to 23 billion euros from reduced profit shifting. But the revenue these countries could have collected from the low tax foreign profit of their own multinationals would be collected by other countries through the QDMT. The magnitude of that is 40 to 49 billion euros a year. So from the perspective of national interest, this is a very expensive way to raise revenue. You collect 21 to 23 billions of revenue by giving away 40 to 49 billion of revenue to other countries. Here I note that for scholars, even if you believe tax competition diminishes the welfare of headquarter countries, no theory or evidence has been provided that the magnitude of such welfare loss is as large as the clear wealth transfer under Pillar 2. Okay, so now suppose that the government of Canada comes to the government of Hong Kong and proposes the following. Our multinationals are paying too little tax on their profits overseas. They're not contributing their fair share of tax revenue. We figured out a solution. You, Hong Kong, should be taxing our multinationals more. We will help you collect this tax by imposing a top-up tax in our country, but let you collect the top-up tax instead through enacting a QDMT. What do you think Hong Kong's response should be? I think Hong Kong, we've heard Hong Kong's answer. It is, sure, we will absolutely do our part in international cooperation, taxing multinationals. But that is sort of code word for that's an offer we can't refuse. If you like it, if you like to give your national wealth away, we'll take it. Okay. Suppose, however, someone asks the Canadian official, why do you like it that way? Doesn't that arrangement shrink your national income? Isn't that against your national interest? How do you think the Canadian officials will respond? I can tell you, I don't think there's a good answer. All this is to say that QDMT adoption may be rational conditional on IIR adoption. But if IIR adoption is not rational in the long term, then the QDMT may not be sustainable. In fact, the adoption of the QDMT deters IIR adoption by making sure that IIR will collect no revenue. So some governments may hope to find effective ways of attracting foreign investment through other means like business subsidies that would not be as controversial as low taxes. Whether this will turn out to be the case is still to be seen. It's too early to predict that these alternative ways of attracting foreign investment will make the QDMT sustainable in the long term. Okay, now I come to the central part of this talk, which is the UTPR's illusory enforcement powers. Many Pillar 2 proponents claim that the UTPR is intended to force countries to adopt the income inclusion rule. Many also claim that countries, including Hong Kong, should adopt the QDMT in response to other countries' UTPR. I'm going to start by showing an easy argument that the UTPR must fail to enforce IR adoption, and I'm going to come to the QDMT next. Okay, here's the argument. The UTPR either enforces QDMT adoption in countries hosting low tax ME subsidiaries or not. Okay, and so Z could adopt the QDMT in response to the UTPR or not. If the UTPR adopted by country X or Y secures QDMT adoption, for example, by country Z, then the UPE country, the headquarter country U, gains nothing from IR adoption by the preceding arguments. All the revenue that the IR could have collected would have been collected by the QDMT already. Okay, so that's one horn of the dilemma. If the UTPR by X or Y does not secure QDMT adoption by Z, suppose that the headquarter country adopts the IR in response to the UTPR. But remember, the IR itself would trigger QDMT adoption by Z, in which case U again gains nothing from IR adoption. To put it differently, the presence of the QDMT makes sure that IR adoption fails to respond to UTPR adoption. Okay, so this is, I think, an easy argument. Let's look at a second argument that the UTPR fails to enforce QDMT adoption by non-UPE countries. So there are a few more steps, but I think it's still pretty intuitive and straightforward. I'm going to start by interpreting the UTPR as a non-extraterritorial instrument. That means the UTPR jurisdiction, X or Y, only taxes the profit of a multinational subsidiary located in that jurisdiction. This interpretation is consistent with the Pillar 2 model rules. I'm going to show, I do show in the paper that alternative interpretation actually will give rise to the same incentive effects. Okay, so let's stay with the non-extraterritorial interpretation. Let's consider a low tax country Z and whether it will apply the qualified domestic minimum tax to a multinational in response to another country's adoption of the UTPR. I'm going to make the following plausible assumptions. M's project in X or Z may be marginal or inframarginal. That means either the project barely makes even or it earns a positive profit. I'm considering X and Z because only if M operates in both countries do we have this issue about adopting the QDMT in reaction to the UTPR. Negative profit in any country means that M is going to exit the country. There's nothing to tax there. Finally, I'm going to assume that M has other marginal investment opportunities. Okay, so X is the country considering adopting the UTPR. But if the project X is marginal, X cannot levy UTPR because any more tax on the X project will drive M away. If M exits, there's nothing to impose the UTPR on. So it doesn't matter what Z's project is, as long as X's project is only marginal, X is not in a position to impose the UTPR, in which case Z has no reason to impose QDMT. Okay. Consider the scenario where Z's project is marginal only with a subsidy, which is why there's a low tax in country Z. Okay. But X project is inframarginal. In this case, X is in a position to impose the UTPR, imposing the tax would not drive M away from X. It would stop M from investing in Z. Okay. The reason is that taking the UTPR tax into account, the project in Z is going to be negative profit. Okay. But if that is the case, it doesn't matter whether Z removes the subsidy. It doesn't matter whether Z enacts the QDMT. If it removes the QDMT, if it imposes the QDMT and removes the subsidy, the project in Z is no longer viable. If it doesn't do it, but there's a UTPR imposed with respect to the project is still not viable. So there's nothing that Z can do about X's imposition of the UTPR. Therefore, it has no reason to impose the QDMT. So if you follow those arguments, the only remaining possibility is where Z and X projects are both inframarginal. And so M, the multinational, can be taxed either in Z or be taxed in X. Should Z tax M's profit in Z to preclude X from taxing M's profit in X? That is a mouthful, but that essentially is the question. Okay. But this is very strange. Why should Z tax M's profit? Only X threatens to tax M's profit in X. Why shouldn't Z have taxed M's profits in Z already? And why shouldn't X have taxed M's profit in X already? Why is it that they're thinking of taxing M's profit only when the other does something or not do something? It's pretty hard to come up with a coherent story to explain this. Okay. So this narrative works better only if the UPE jurisdiction, country U, is considering the QDMT. This is because in that situation, we have an answer to the question, why isn't U already taxing the multinational? The answer is that M's profit is part of U's national income. So even if U is a national income maximizing country, it does not necessarily need to tax M because taxing M is just a matter of transferring wealth within a country. So it follows that the UTPR may be effective in forcing QDMT adoption only in UPE countries. Okay, so these conclusions should be surprising to many of you. The overall conclusion is that the UTPR has enforcement power only in limited circumstances and lacks such effect in most policy relevant circumstances. What I mean by policy relevant circumstances, we really should think that marginal investments are the relevant circumstances. If Z is giving subsidies to M, presumably it believes that its projects are marginal. And if X is not taxing the multinational more, presumably that's also because it believes the project is marginal. Okay, so I've gone through the key arguments of the paper. I'm going to go through the rest. These are they involve arguments that are complicated. I'm going to just quickly give you a flavor of what they involve. Okay. So far, as I said, I've assumed that the UTPR is interpreted according to the text of Pillar 2 model rules, that it's a non-extraterritorial instrument. That means that UTPR jurisdiction can only tax profit located within it. But what if the UTPR is an extraterritorial instrument? What if X can tax the profit of the X subsidiary, the Z subsidiary, and the U subsidiary? Okay, many commentators on Pillar 2 actually write as though the UTPR it can be interpreted this way. So consider the following idea. I'm sure that people are hearing about it. If Hong Kong does not tax a Hong Kong co's profit, someone else will tax it meaning the profit in Hong Kong. Okay. This is actually inconsistent with the text of Pillar 2 rules. Nonetheless, that has not prevented people from using this interpretation. So, but in my paper, I say, let's consider this possibility. What's the problem of this interpretation? I argue that it would amount to the creation of a new taxing right. And this is a new taxing right which is too tempting for national income maximizing government to adopt. And it's going to be to the detriment of other countries. I'm not going to have time in this talk to go over them in detail, but in the paper, I discuss how this new taxing right compares with traditional taxing rights under controlled foreign corporation rules. I argue that they should be separated from foreign tax credit designs in international taxation. And I argue that what's problematic about this taxing right, the idea that X can tax profit anywhere in the world, even though it has nothing to do with X, is not that it's arbitrary. It is arbitrary. But the most important issue is that it's going to be to the detriment of other countries, and it's going to give rise to conflict. And so it's hard to imagine that the exercise of such a right can be restrained. It's natural to express this view, this argument that I just summarized, by saying that an extraterritorial UTPR would be against international law. Interestingly, there's a debate among scholars about this issue, but it remains obscure among the wider in the wider world. The most important takeaway from the scholarly debate, I would say, is that just because there's no existing positive law that says something cannot be done, it doesn't follow that it's legal to do it. Okay, this is because we want to be asking questions such as, should countries be allowed to tax profits unconnected with them? This is not just an ethical issue, it's also a legal issue. It's hard to imagine that countries are unconstrained. So I would say that even proponents of the UTPR should reject the extraterritorial interpretation of the UTPR. We should also ask questions such as, should countries be allowed to adopt measures aimed at neutralizing tax incentives in other countries? Is there anything that limits the discriminatory application of the qualified domestic minimum tax? All these questions have still not really been widely discussed, but I would say that it should be recognized that national governments that have sovereignty, are accountable to international law. The OECD is not. Okay, the OECD is not going to be called to court, but national governments will. And therefore, the Pillar 2 process, even if it has sidestepped international legal issues so far, it doesn't mean that that will continue in the future. Okay, I want to be wrapping up, and so I'm going to quickly talk about possible objections. The main objection I can think of that I've gotten from past presentations is, should we predict the behavior of countries on the premise that they maximize national income, which is the premise adopted by my argument so far? My first answer is, let's ask the proponents of Pillar 2. Here I have quotes. Some of you have read these. EU Tax Commissioner Paolo Gentiloni says failure to adopt the income inclusion rule will result in the immediate loss of tax revenue. I've just shown you in my arguments that adopting the IIR will result in a large loss of national income. Paolo Gentiloni claimed the opposite, and that was offered as a reason to adopt Pillar 2. OECD Secretary General Matthias Cormann says once there's a critical mass of countries on board, it becomes very hard not to become part of it, because essentially you leave money on the table for other countries to collect if you don't adopt Pillar 2. Pascal Saint-Amand says if somebody just grabs the tax, your tax, well, you will not let it go. You will act yourself. Former Deputy Assistant Secretary of the Treasury, Kimberly Clausing, says countries that enact the agreement's provisions will be able to tax multinational companies based on in countries that do not adopt the provisions. This provides a strong incentive for countries to eventually follow through on their pledge to abide by the agreement. What I want to show is that all of these proponents of Pillar 2 are appealing precisely to a national interest. And what I've shown is that if we think of countries as maximizing national income, then conclusion should be the opposite of these claims. Many commentators, including scholars, also have claimed that Pillar 2 is so-called incentive compatible, displays a diabolic, devilish, very clever logic, or offers novel enforcement mechanisms. So all of these comments are meant to say that compatibility with national self-interest is an essential part of Pillar 2 design. And what my arguments have tried to show is that this is wrong. Okay. Do we think that countries are maximizing national income, acting in defense of their national interest? Well, why else are countries fighting tooth and nail over Pillar 1, digital services tax, and so on? I also want to point out that if you look at the OECD's recent publications, it seems to have been promoting Pillar 2 as though governments are revenue maximizing. As long as Pillar 2 generates a lot of revenue, that seems to be enough of a good thing. That's the tenor of the OECD's publications. And if you ask which is more plausible, do governments seek to maximize revenue, or do they maximize national income? I'll say that governments will say to the public that they seek not to maximize national revenue, but they try to maximize national income. In short, national income maximization is certainly a simplistic predictor of country behavior, but there aren't many or any superior alternatives, and we should not use this idea only when convenient. We shouldn't promote Pillar 2 in a given year by appealing to national interest and then say we don't believe in national interest or national income maximization. Here are the quick implications for Hong Kong. The Hong Kong minimum top-up tax, which is the Hong Kong version of the QDMT, may be rational for now to adopt, but primarily as a response to anticipated income inclusion rule, according to my argument. It should not be a response to the adoption of UTPR by other countries. Hong Kong needs to recognize that Pillar 2 will come at a large cost for countries like China, the US, Canada, and so on. And it's not clear that such countries will be willing to bear such long costs or do so, indefinitely. Hong Kong government has also proposed adopting the income inclusion rule, subjecting foreign income to Hong Kong taxation. I believe this is, as a response to Pillar 2, is harder to justify than the QDMT. And then finally, adopting the UTPR in Hong Kong, I think, based on the arguments, based on the reasons I offered, is legally and economically risky. And it is risky or even reckless for other countries as well. That is the end of my presentation. Thank you for letting me go on for 40 minutes.
Thank you again on behalf of everybody who's attended the webinar today.
Thank you, everyone, and thank you, Richard, for hosting me.